We're ready to start. Again, thank you for being here this evening. Couple of things just to get going. First off, I want to thank Wayne County Development District for having me this evening. Very happy to say that I have spent better part of the last year traveling extensively in Mississippi. And it's been a very, very wonderful experience in reference to the hospitality and the wonderful people that I've met throughout this last year. People quite often will ask me why I picked Mississippi. And there's really a simple answer for that. When the oil spill happened in April 20th of 2010, the BP went through, had a PR campaign where they indicated to the public that they were going to compensate the millions of businesses that were affected by this horrible disaster. And there was so much misinformation that came from them that most people that have been affected by this and possibly could have a claim were simply misinformed and did not know their rights and did not know whether or not this particular claim was speaking to them. So Mississippi, like the other 4 states, and just so we know what we're talking here, talking about every business in Louisiana, every business in Mississippi, every business in Alabama, a small portion of northern eastern Texas, and the whole west coast of Florida, from the Panhandle all the way down to the Florida Keys. Every business in that zone, and we're going to show you a map in a few minutes, have a potential claim in this class action settlement. Before I go any further, I just would like to say that this happened almost 5 years ago. And initially, there was going to be a 2-year limitation or a 2-year deadline on your ability to file a claim. Because of BP's bad behavior and because of some of the things that were written into the agreement, that has been extended to June 8th of this year. So if you get anything from this webinar tonight and you are interested in moving forward on this, the most important thing that I can tell you is that you have a very, very limited amount of time to actually move forward on this. Since the announcement of the settlement in 2012, there's been 306,000 claims filed. We believe that is less than half of all of the total potential claims that could have been filed in this case, which means simply about half of the businesses out there that had potential claims have yet to file their claim. We anticipate that by June 8th, those numbers are not going to drastically change. So what does that mean? Essentially, that means that if you don't file your claim by June 8th, you're going to be barred forever in having an ability to potentially have a settlement with BP. So this is pretty much going to be the last time that I'm going to have an opportunity to speak to business owners and indicate and tell them what they need to know about this settlement and whether or not they would be interested in moving forward on this. And unfortunately, that is a tragedy in itself. If you look back at the Exxon Valdez type of case involving the oil spill in Alaska, that litigation went on for over 20 years. This was a business decision that BP made early on after the oil spill. They were willing to pay the claims, but they wanted to get this off of their balance sheet as quick as possible. That's what they initially wanted to do. Unfortunately, they entered into a settlement agreement and they backed out or attempted to back out of that agreement. And now we're at almost 5 years. So let me backtrack again and go back to my initial comments as to why Mississippi. Well, I believed early on that because of the lay of the land, for lack of a better word, there were going to be a lot of Mississippians that either, one, didn't know about the settlement, two, were not aware that the settlement applied to them, or three, received a lot of misinformation from British Petroleum as to what the settlement actually was. So let's go back, and we're going to start the slideshow in a little bit, but let's go back and just talk about the events. The events were April 20th, 2010. We all know what happened. Wayne County was affected much differently than most of the Gulf region in that one of the 11 individuals that lost their lives in this tragic event were actually from Wayne County. So when this happened early on, BP decided that they were going to put up their own fund together and compensate the victims of this incident. So they literally went door to door and made their own decisions who they thought should be compensated versus who they thought shouldn't be compensated. You're a fisherman, you're on the coast, we're going to compensate you. We're going to determine this is what we think you deserve. You're a dentist on the coast, it doesn't apply to you. You're a fisherman who's off the coast. Maybe you fish out of a river. It doesn't apply to you. So there was an unfairness that resulted out of what BP was attempting to do. So a lawsuit was instituted, and it was a class action lawsuit of all those businesses that were directly and indirectly harmed by BP who were not being compensated. Initially, BP fought this, and in 2012, a settlement was reached. And the settlement basically was very simple. It was a 1,000-page settlement agreement. That doesn't sound simple, but essentially what it was is as follows. BP was going to take $20 billion. They were going to give it to the court, the trustee, appointed by the federal judge, and there were formulas that were going to be used to decide whether or not a company was entitled to compensation. Unfortunately, BP tried to get out of their own settlement agreement. And much of what the public has heard since 2012 involves BP challenging their own settlement agreement. In December of this year, the Supreme Court had decided not to listen to any more arguments made by BP, and essentially the case is over. So we have a fund that has been set up that the trustee manages, and individuals in the 5 states that we've just mentioned have a right to present a business claim. There's 13 different categories of claims. Our law firm is only specializing in business loss claims. So currently, out of the claims that have been presented, about 35% of those claims out of the 306,000 claims, 35% of those claims have been British business claims, the type of claims that my law firm presents. So far, over $5.3 billion in claims have been presented to the fund, of which $3 billion have already been paid out. The average settlement is $170,000, and 42% of all the claims that have been submitted, the business claims only, 42% of those that have been filed completely and accurately are processed for payment. So essentially what that means is just about every other client that we meet that meets the criteria that we're going to go through in a little bit, their claim is going to be paid. Mississippi, businesses in Mississippi, only 36,000 businesses in Mississippi, actually the number is 36,482, have actually filed claims. The Small Business Administration estimates that there are 240 billion 240,000 businesses in Mississippi. So only about 15% of the eligible businesses in Mississippi that could have potentially filed claims, only 15% have actually filed them. So although lawyers like myself have been in Mississippi, attempted to get the word out, only about 15% of those businesses have filed. So that's why Larry Moskowitz from Fort Lauderdale, Florida, had decided that he wanted to spend his time in Mississippi. I had had friends in Mississippi. I had done legal work in Mississippi before. I had clients from Mississippi, and I knew that Mississippi was going to be a state where this information was not going to readily be available to the businesses and the citizens of Mississippi. So I think the best thing for us to do now is simply, we've got a slide presentation, a PowerPoint. It's got about 10 slides to it, and it's going to succinctly go through what this is about and whether or not you should be filing a claim. My humble opinion, every business in Mississippi should be filing a claim. This is not a handout. This is not a freebie. This was a well thought out plan as to why businesses deserved and were entitled to compensation. It was based on direct and indirect harm that was caused by this disaster. So let's go. We'll start with slide 2. You're not going to see me for a while, but you're going to hear me. Okay, so the presentation tonight is what BP doesn't want you to know and what businesses should know. Okay, so the BP settlement program was a landmark class action settlement specifically designed to resolve the massive number of valid legal claims for economic harm that were created by the April 20th, 2010 oil spill that further stalled our economy. So we'll get clients that call us all the time or that we're speaking to all the time, and they will not be able to put their arms around initially the fact that although the economy in the US in 2010 was slowed, recession, what have you, the bottom line is that this spill caused a great deal of more depression, recession, and stalled economy in the Gulf region. It was a trickle-down effect. People were not spending, people were scared, and they were not traveling, and there was a very marked loss of revenue as a result of tourism in those Gulf states. And again, I'm going to repeat this probably 10 times before the end of this. The deadline is June 8th, 2015. If you are a company that has financial records that are readily available to them, we can still file your claim. However, our law firm is going to stop taking new clients on in the first week of April. The reason being is simple. We don't want to take a client on and be responsible for filing that client's claim close to the June 8th deadline if we feel if there's any chance that we're not going to be able to accomplish that for the client. So that's why we've decided as a law firm that the first week of April is going to be the last time that we're going to entertain taking new clients on for this particular matter. Anyone that's on the webinar tonight, watching the webinar, you have time. If you have organized financial records, we're going to give you my phone number at the end of this. You're going to be able to contact me over the next couple of days if you're interested, and you'll be able to discuss with us the filing of your claim and whether or not it's right for you. Okay, so why was this program created? So here's just a little bit of information that we're talking about here. I just kind of touched on this, so we'll be brief here, but the oil spill came at the time when the U.S. economy was already slowing, and it caused the economies of the Gulf states to drop more significantly. Sometimes we'll have business owners that feel that maybe this is immoral or is getting something for nothing. I assure you that this program was set up only for businesses, and the formulas were set up so that only businesses who truthfully lost revenues as a result of this incident are going to be compensated. Okay? This is not, let's get BP, let's punish them. That's not how this was created. So the trickle-down or indirect economic consequences resulted from the drop in consumer spending and halt in tourism. I think that's kind of obvious. BP created and funded the settlement program so all businesses in certain geographic areas can get evaluated to see if they are entitled to compensation. So I'm going to show you right now what we're talking about. Here is a map that was created by the parties, BP, and as you can see, Louisiana, Mississippi, Alabama, all that gray area is actually part of the settlement. There's different zones based on how close you were to the Gulf. However, every business in the state of Mississippi qualifies. So that map is telltale. I personally, my first trip to Mississippi, I started in Jackson, and I actually went north, not south. I never even made it down to Biloxi, believe it or not. I just went north. I was meeting people in Tupelo, Tishomingo, and our IT guy is coming in to change something here. What happened? Slideshow's not showing?
There you go.
Okay. We got to go back?
Nope.
All right. So, okay. So, let's go to the next slide here. Here's the basic operation of the program. Program was created by BP with the federal court approval to ensure payment of legitimate claims by businesses in the affected geographic zones. I don't know if any of you have heard or seen some of the advertisements that BP has put out over the last couple of years regarding fraud, regarding illegitimate claims, what have you. I assure you that it was done to prevent honest people from filing claims. It was that simple. What they wanted to do is they wanted to siphon off the ability of individuals to make a valued decision of whether or not they should file claims. And although they put this money into a fund to help businesses, at the same time they were sending out propaganda trying to dissuade people from actually filing the claims. So the economic formulas of the program work to identify those who were directly or indirectly harmed. This is a very big point. Most times when we meet clients, they go, well, you know, I didn't have oil splashing up on my front door. Again, this is a trickle-down scenario where, and here's an example. I make t-shirts. I'm in Jackson, Mississippi. My clients are in Panama City in the panhandle of Florida. They're all beachfront type, tourist type businesses that we make t-shirts for. Well, guess what? When Panama City was a ghost town and no one was buying t-shirts, the t-shirt manufacturer in Jackson, Mississippi was indirectly harmed by the oil spill. And that's essentially how it goes. So to put your arms around this is pretty simple. It's a trickle-down effect. And there you have it. So the program was meant to be an objective, fair, and transparent evaluation process so businesses can obtain compensation for their financial statements and when their financial statements support it. And we're going to talk about what you need to bring a claim and what have you. So it's going to be based on the finances. Okay. There's no evidence of any rampant fraud occurring. With all the fraud protections in place, it is unlikely that fraud claims would be successful. Damages are calculated exactly as BP agreed they should, and the program is strictly confidential. We have, just by way of history, we at one time, our firm strictly handled these claims, was the largest doing that, and we've got over 2,000 claims pending, something like that. And we've got businesses that range from very small businesses to Fortune 500 companies. And a lot of times with the very large companies, this comes up regarding confidentiality. And it doesn't matter if you're large. You know, if you don't want your neighbors to know, if you don't want your competitors to know, there's a lot of reasons why you would want this confidential. The bottom line is this. Attorney-client privilege makes it confidential, but more importantly, or maybe not, depending on who you ask, the federal court has mandated that all settlements are confidential. That means that no one will even know that you filed a claim unless you care to tell them. So that's an important thing for some people. Okay, I'm going the wrong way here. So let me try to get see if I can go down here. I have something on my screen here that's preventing me from seeing this bottom. So I can move that. Hold on. Oh, here you go. It's hide. I see it. Never mind. Never mind. Got it. Oops. What did I just do? What did I just do?
Where do you
I
want to go?
tried to, yeah, I was on like, oh, okay, I'll just go back on the slide here.
You want to go over here?
No. Yeah, okay, got it. Okay, so here you go. The last bullet point here. For businesses with existing financials, the evaluation process can be fairly short and simple, which is true. We can handle very large companies in that matter as well. We just took on a company within the last 2 days. Obviously it's confidential, but they do about $2 billion in sales, and we're going to be able to evaluate their claim within the prescribed time period with no problem. So if you're out there and you have a large business, I'm going to discuss with you. There's a train coming. I hope that doesn't bother you too much, but we're right close to the train tracks here. But I'm gonna pause here for a second just in case it's causing some difficulties. Okay, let's go to the next one. Okay. What happened? It can't be seen on that, on the side? What happened?
You're good.
Okay. Wait, no. Wait. Okay, here we go. Okay. Again, we're going to talk about there's no evidence of rampant fraud. A lot of these bullet points we had put together over a year ago when BP was just in the, was just every week they were coming out with something new. They were doing full-page ads in the Wall Street Journal. They were alleging all kinds of things that were simply not true, but they were attempting to get the public nervous about the potential of them filing a claim. And to be honest with you, we had to fend off these type of questions on a daily basis. We would meet with a CPA firm. They would say, our clients are concerned that they're going to be looked upon as fraudsters, what have you. They read something in the paper where there was one person who might have been a criminal, that kind of thing. So there is no fraud that we know of that's running rampant. Okay. The damages are being calculated by a formula that is exactly as BP agreed. And the program is strictly confidential. Okay. Here's the proof about the program. The media campaign that was merely a tactic by BP, it was designed to chill legitimate claims by the very businesses it was designed to help. Essentially, BP wanted to keep that $20 billion as close to the vest as possible. By the way, whatever is not paid out in claims will be returned to BP. Attempting to cut billions in claim exposure, yet still wants the program to succeed, resulting in future claims being forever barred. So what they were doing is they were using this propaganda to prevent people from wanting to file a claim, but at the same time, they didn't want the program to go away completely because they were very happy that this is going to expire on June 8th and they'll have no more exposure after that date, as opposed to other types of massive class action lawsuits such as the Exxon case that I talked about earlier. BP essentially has lost all court challenges to date. There will be no more legal options. They've tried everything. They've gone to the Supreme Court. The Supreme Court has denied even considering it. So the bottom line is that this program is fully active and the claims are being paid each month. Okay.
It's not switching slides. It's just keep it here.
I don't understand.
All right, yeah. Just
What do you mean?
use the thing on the left to switch.
I did that.
All right, you're good.
Okay. All right. So this is the part where, if you're interested, this is the part that you got to pay a lot of attention to, because this is what we're going to need from you. Okay. So here, this is how we determine a claim. Essentially, what the idea behind the formulas were, or was, is to compensate businesses for 8 months of lost profits during 2010. That was the intent. What we're going to need from businesses to evaluate your claim is monthly P&Ls, profit and loss statements, from 2007 to 2011, and tax returns during those years. The tax returns are used to match up against the P&Ls for fraud, basically. And the P&Ls are really where the analysis is. Every month, it's an analysis of 3 consecutive months of 2010 profit and loss versus your historical 7, 8, and 9 and your 11. And what we're looking for is we're looking for a V, or we're looking for the test for causation. So we're looking for a dip in profits in 10 and then a increase back up in 11. We're going to take your profit and loss statements from 7 to 11. We're going to take 10, January, February, March, and we're going to match it against 7. We're going to match it against 8. We're going to match it against 9, and then we're going to match it against 11. And then we're going to take February, March, April. We're going to match it against 7. We're going to do that. I don't remember if it's 66 times or I think it's 68 times. We're going to do it a whole bunch of times. If we get the V that we're looking for, you're going to be paid the highest claim value that is determined. And again, about 42% of the time, we're going to find that for you. Okay? There are no roundabouts for the information that we're going to need. In other words, this is a requirement that has been set forth by the settlement agreement. This is part of the formulas. This is mandatorily required by the fund. It's not something my law firm came up with. It's something that must be done. So if you can't produce monthly P&Ls, unfortunately, at this late in the game, there's no way for us to evaluate your claim. So it's this 3-step process. It's a reduction in variable profit and loss growth opportunity, and includes a multiplier of risk transfer premium. We'll get to that in a minute. Essentially, what we need for you to understand is this. This is not normal accounting. This is accounting based on the formulas. A lot of times what we're up against is we're up against our client's CPA, who sees that something happened in 9, something happened in 10, something happened in 11, and they give their client a quick, you don't have a claim because you made more money in 10 than 9. That's not how this works. We cannot determine whether or not you have the causation we're looking for until such time as we peel back that onion and we actually run the numbers. Every time we're in front of a client, we're asked immediately to kind of give our snapshot of what we think, and unfortunately, we just can't do that. Here's the really good, the good stuff. Here's the good stuff. We're going to do this for you, and we don't charge anything. We only get compensated for our legal work and accounting work when you have a valid claim that actually is paid. Okay, so let me go back to 8. So here's how it works. The federal court has set the fees at 25% of the gross recovery. Essentially, the risk transfer premium, what that means is that when the settlement was reached, all the parties involved knew that attorneys and accountants were going to have to be hired to figure this out. So they put a multiplier in the settlement. So essentially, the minimum multiplier is 0.25. Our fees are capped at 25%. So essentially, there is no legal fees if you don't have a claim. And if you do have a claim, our legal fees are pretty much taken care of even when you do have a successful claim. Again, it's not dollar for dollar, but it's pretty close. So you're basically getting us for free. So going back to my initial comments, I don't know why every business in Mississippi wouldn't want to see whether or not they have a claim. Okay, so here are the totals that we sort of talked about. The average claim's 166,000. It varies. At one point, it was 240. I have 170 on one document. I have 166. It's a substantial amount of money. Our claims in our office tend to be higher because we tend to have some bigger businesses that kind of bring up our values. But you know, there are individuals that are smaller companies, what have you. That's the average. It's real money. It's definitely worth looking into. A lot of times our clients ask us, you know, how long is this going to take? Well, unfortunately, if any of you guys are going to file a claim with us in the 11th hour or whoever you may choose, it's just like waiting in line in Disney World. Your place in line is going to be, you know, last. You're going to be last. At some point, you're going to be the last person filed. The good news is that because of all the legal stuff is over and the deadline is on June 8th, it's my opinion that things are going to move much more rapidly than they have in the past because there'd be absolutely no reason for anyone to keep that money in the trustees' coffers versus giving it to the businesses who need it. So essentially, that's pretty much our presentation. If there are any questions, I'm going to open up the line right now. I have an indication of how many people are on, but let's see how this goes, and we'll go from there. So let me see first if there's any emails that I might be able to answer. And then we're going to open it up right now. Let me see what I do. Here we go. Okay. Hi, Joseph. Are you there? Not so great. Here now. Okay, now I can hear you better.
Okay.
Are you guys over at the wing, the district there? Are you having
Yes,
your?
sir, we are. We're at the district office. Yes, sir.
And you're having your meeting?
Yes, sir. And we do have a question for you.
Yes, please.
The question is, we've got a person here that went into business around 2008. So they were not in business in 2007. The question that was slipped down to me on a piece of paper is, how is that going to affect their ability if they don't go back to 2007?
That depends. That's a great question. To find causation, we would like to have all of those years. However, no. To answer your question, no, we should. If that individual is interested, we should still be able to evaluate their claim. You know, a lot of times it gets tricky when we have people that have bought businesses, and we need to know whether or not it's an asset purchase versus a buying the whole company with the liabilities. Sometimes we have breakups in the businesses where those 2007s may not be available. So we have done it in the past. The real trick here is to make sure that they're monthly P&Ls. That's really the key to having any success with the evaluation. If you can't produce the monthly P&Ls, we're not going to be able to help you, and no one's going to be able to help you, unfortunately. So I hope that answers the question. Yeah.
It does. Basically, here's the second part of that. The business was actually a startup business in 2008, so it did not exist before this particular time. So that goes to the heart of the question.
Yeah. And again, there is actually a part of the fund that deals with startup companies. We unfortunately do not evaluate those cases. I don't think that this individual, female or male, I don't know who it is, but I don't think they would fall into the startup category. So that would be something that we would look into for them and give them an answer relatively quickly. The nice thing about how we've set things up is we've done everything in-house. Other firms, and obviously anyone can go and pick anyone who they choose. There are some people out there that do a nice job, but fortunately for us, we have always done it all in-house. So we have proprietary software. We have our in-house accountants. At one point, we even had hired a forensic accountant that used to work for the BP fund to come in to quality control our work before we sent it over to the trustee. So we have a machine, for lack of a better word, or a mechanized system to get these claims handled quickly and to get you answers very quickly. It should only take a matter of a couple of days from when we get the information to give you some sort of preliminary response as to whether or not we should pursue it.
We have one more question
Sure.
here that said it was questioning your deadline of early April.
Yes.
Is there a particular day in early April? I'm reading this here, handwritten note. Is there a particular day in early April that you're just going to say that's it?
Well, we've come up with the date of April 3rd. That date has been determined by a collective decision-making process. You know, I gotta be really candid. The easy part for us has always been getting the clients to agree to move forward. The challenge has always been for us to follow up, or the clients actually following up with us to getting us the materials. It's kind of like your accountant begging you to bring your stuff in to do your taxes, and you know, we all seem to want to procrastinate that type of scenario. So what's happened over the last several years that we've done this is people get very excited, and then they go on vacation. Something happens where their accountants went on vacation or whatever, and it's been a challenge for us to get the client to bring us what we need. So why we picked April 3rd is to protect ourselves so that we're not caught in a scenario where we've brought on a client and now we're begging, for lack of a better word, the client to bring us those materials before the June deadline. So actually that date has really been set up for us to make sure that we don't commit any type of issue. So for instance, if you came in my office on April 4th and you had every single document that we needed with you before you signed our agreement, I wouldn't say no to you. But so what we've done in the past is we've given our clients basically, okay, you have X amount of days to bring this to us, and if you don't, you're going to get a rejection letter from us, because we don't want to be in a situation where our client goes to Europe, calls us on June 9th and says, how's my case doing? And we're like, well, we couldn't get a hold of you because we needed this, that, and the other thing. So, you know, we're going to stick to April 3rd unless something strange happens where maybe that person got sick on April 3rd and brought it in April 4th. So we're going to give ourselves enough cushion to make sure we can get the work done. I hope that answers the question.
Oh, that does. And none other questions been passed down to me, so I'll give it to somebody else.
Great. Okay, so I've got a couple of people that have emailed, and we're just going to take those one by one. One of the questions that has been asked of us is whether or not it would be possible that a competitor would get the information. So this has come up a lot with us. Couple of things. One, the way we've set up our practice is that even if you're in the same industry, one lawyer is not going to look at a file or multiple files of the same industry. We've set up some procedures where there's some Chinese we call them Chinese walls in our office. So the answer is no. The most sacred thing that an attorney has with a client is attorney-client privilege and confidentiality. Being a former prosecutor, you know, it doesn't get any more confidential than in the criminal area. So the answer is no. There's no way that that's going to happen. It's not going to happen in our law firm, and I wouldn't think it would happen in anyone else's law firm. You got a federal ruling. You know, we even have public companies that report publicly their financials, but have some proprietary information in the way that they do their accounting that they don't want their competitors to ever see. And we have engaged them, and we have been very fortunate to have those clients come in, and we're honored to represent them. So that's not an issue. Next issue is, what about if my business failed in 2011? Okay, that's a good question. Here's how this goes. When they came up with the settlement, there were certain categories of different types of claims. There's an injury claim, meaning you were physically injured by the oil, you got sick, what have you, a personal injury. Has nothing to do with business. There were situations where, I lost my train of thought here, but there were situations where businesses failed, businesses only declined in revenue, gross profits. Here's how I need to make sure the constituents that listen to me understand. As a law firm, we decided that we wanted to only concentrate on the business losses, or the BEC claims, the business economic loss claims. The reason being is that some of these other categories, the requirements and the collateral documentation that you would need to provide, for instance, if a business went out of business, receipts, other types of background materials, simply our clients were unable to produce them. And those claims are only being paid less than 5 to 10% of the time. So we decided that that was not an area we wanted to be in. But I want to make it very clear, if you fit into those categories, you can still find another firm possibly that would handle that for you, or you could even try to attempt to file it yourself. But that's not something that we would want to handle at this hour, certainly not. Okay, so hopefully none of you are in that category or those other categories, but if you go to our website, erglawfirm.com, we actually have a copy of the settlement agreement that lines out all of those other different areas of the settlement agreement. One question is, oh, here's a good one. Okay. What if I live in Tennessee, but my business is in Mississippi? I get this all the time. Okay. The way that your business is going to be determined if you fit into this map that I put up is where you filed your EIN number. So if you've been filing your tax returns on your business in Mississippi, then you're in Mississippi. And it also makes a difference as to what zone you're in. So if we could go back to that map for a minute, because I'm going to guess that other than this one email that I got, I'm going to guess that most people that are listening tonight do have businesses in Mississippi. But this does come up quite often, so I just want to touch on this for a minute. If you look at my slide here and you see you got red, you've got yellow, you've got purple, and you've got gray. The outlying yellow we like to call like the island areas, which are really just right on the coast. The requirement for causation and the dip in gross profits in 2010 is less, you have to prove less as you get closer to the water. So if your business hypothetically was in those areas, let's say Biloxi or what have you, and that's where you filed your EIN number, but you have operations all over Mississippi, you're going to have a better chance of recovery if your EIN number is in Zone A versus if you're all the way up here in Tishomingo. So it does make a difference. Also, and I don't know if this applies to anyone that's listening tonight, but also a very strange part of the settlement. I guess strange is a bad use of a word. But what's nice about the settlement is if you have operations in Mississippi, and this is basically your management area of your company, but you have operations all over the U.S., and we do have companies that fall into this, those other operations are going to fall into the settlement and are going to be reviewed. We had one client that had their main company headquarters in Tampa, but they were an international company, and they had, I think, about 150 retail operations all over the U.S. Every one of those operations, because they were in Tampa, qualified for the settlement. Unfortunately, conversely, just the opposite is true as well. We've got a lot of companies that came out of Miami that had huge sales forces that were all over the west coast of Florida. Unfortunately, none of those companies in Miami would qualify because, like what we just discussed, where if you were out of the zone but your operations or your management was in the zone, your EIN, you would qualify. Just the opposite is true if you're out of the zone. So it's a double-edged sword, so to speak. The theory behind that is that if your management center is being hit by this disaster, then it should have affected the rest of your operations to some extent. So that's how that was the theory behind that. So I don't know if anyone is in that category or not, but I'm glad someone asked the question. I have on the slideshow, we have left some phone numbers, and it's also on our landing page on the website. But if you'd like any further information, or if you'd like to discuss with us your potential claim, The number that I'd like you to call is 601-568-2580. It's going that website is going to remain up. So if you don't have a pen to write it down, or maybe Sean or someone can help you get a hold of us, go ahead and just feel free to give us a call. And I hope this evening's webinar was informative. If anyone has any other follow-up questions, I'd be more than happy to take them. And as always, I want to thank the guys from Wayne County Development District who helped us put this together. Really fortunate that I was able to come down there or up there and meet you guys. And if there's anything we can do for you, let me know. And all I can say is wonderful things about Mississippi. Except, of course, I'm a Gator fan, but we won't go there. All righty. Thank you so much. Anything else? Good night.